This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning to everybody in Radioland. This is Ask a Lawyer, and I'm Stuart Address. Give us your calls at 340-1590. I'm happy to try to answer them. I can't pretend to know it all, but if I don't, I'll tell you. And for those of you on Facebook Live, you can call or you can type your questions if I see them. And pretty soon we're going to be able to have a situation where on Facebook Live you'll be able to actually hear the questions. So look forward to that. It may take a few weeks. You know, Cliff, before the show started, while he was doing Swap Shop, mentioned, some lawyers will charge you if they wake up in the middle of the night, think of something, and go back to sleep. That's true. All right, no, I don't do that. If I wake up in the middle of the night, and I then go to the computer and I start working, you're going to get billed.
It's per every DM.
Yeah. And if I wake up and I start doing emails at 2 in the morning, yeah, if it's an hourly case, you're going to be billed. If it's a contingency case, breathe easy. Lawyers do wake up in the middle of the night, sometimes because they're getting older and they got to use the facilities, and sometimes because they got cases on their mind.
Lawyers aren't the only ones who are waking up in the middle of the night, pal.
So we sometimes we take the work home and it percolates while we're sleeping. I guess one of the other things is I've been trying to talk over the last few weeks about topics that have been in my office of late. We spent a couple weeks, we spent 1 week last week, talking about partition of real property when your tenants in common or your joint tenants, and we went through, some may say ad nauseum, into all the considerations that go into getting what your interest is in a property if the other doesn't want to sell. So, I was thinking, what do we talk about today? And there's another, by the way, before I do that, I went home after the show on Friday, and I work from home on Friday afternoons, and I immediately started doing a demand letter on partition of property. So I took my notes for the radio show, and it really helped.
Okay.
But it does sort of work out that way sometimes. Things are propitious.
So are you throwing a going away party for Sarah Sanders, by the way? I take that as a no?
No, I will let her return to Arkansas, and maybe she won't get indicted one day, but
she can marry Bill Clinton then.
That's not fair. Let her move to Alaska and marry Sarah Palin. And then Mike Pence will really have a fit. All right, so today, another topic of interest lately. We started practicing in our firm within the last couple of years a little bit of family law. Now, I don't take the more complicated cases because I don't think I'm competent yet to do so. Not in that area. There are lawyers who will take everything on anything when they start to practice in an area. I'd rather take the stuff that I feel competent in, grow in it, and begin to take progressively more complicated matters. So if you call us with a family matter that is complicated, I'll refer you to another attorney. If it's something that I feel comfortable in, I'm happy to represent you. And all this grew out of my own divorce. It all grew out of a little battle I had in 2016 with my ex. And I was getting so aggravated. And that's the thing with family law. You get really, really aggravated. And I was getting so aggravated, I decided, if I'm going to be this aggravated, somebody should pay me for it. So I started doing research and taking a continuing legal education class. And began to slowly prepare for entrance into this new area of practice.
You weren't fighting over a dog or a canary or anything, were you?
No, we were fighting over a kid.
That's usual.
Who sometimes I'd like to throw back into the ocean. What can I tell you? And so this ended up leading, one of the things that I was dealing with in 2016 was a motion for modification of the parenting plan. And since I have started to become more familiar and begin limited practice in the area of family law, we've received a number of calls about people wanting to modify parenting plan, which could include anything from who gets the kid when, what the deal is and the terms and the circumstances, child support modification. It can encompass a lot of things. And so I thought I would talk a little bit about motions for modification. And of course, like always, you have a question on something else, overtime, landlord, tenant, who will win the World Series, give us a call at 340-1590. Please don't call me with questions about who will win the Stanley Cup. I know. Or who will win the NBA Finals. I know. Those aren't fair questions. All right, so you have a situation with your ex that is becoming more complicated and adversarial. And you're thinking, gee, I'm gonna take him or her to court. Okay, that's a good initial thought. You call an attorney. The attorney explains, well, the way you do this is you file a motion for modification. And you file the motion, you file affidavits, you file financial disclosures. That's a number of things that have to get done. And then you try to get the motion set for hearing. Good luck. It's one of the things we have to tell people. I myself have tried to get a motion in my own case with my own attorney scheduled as an emergency. The court laughs. Why? Because, again, too few judges, too many cases. If you need to have a motion heard as an emergency, DCF had better be involved, or one parent must be involved in kidnapping the kid, or it really has to be a matter immediately affecting the health or safety of the minor. Other than that, you're not getting an immediate hearing. You're not getting a hearing probably for 6 months to a year, which means you live with the present problems. Although, hopefully, maybe you can resolve them through counsel, especially once a motion for modification is filed. So we get these calls, and what's most often leading to the request for modification? Well, one of them is a change in income by one of the parties, which often leads to a change in child support issues. So we get those calls. Change in the amount of time that one parent is spending with the child. Now, why is that important? Let's say the parenting plan provides that one parent is getting 1/3 of the time with the child. Well, the child support order, if any, is based upon that amount of time. Now, if the time decreases to 25% or increases to 40%, you're not going to get a modification. Modification requires a substantial change in circumstance. And we will continue with those messages right after this call from Jeff on line 1. Hi, Jeff. How you doing?
Hi, Stuart. How are you, Ben? Doing okay?
I'm doing okay. How can I help you?
Well, I got a quick question to ask you.
Sure.
Do certain convenience stores have the right to negate the Florida labor laws because they require you to work 8 hours solid with no dinner, no lunch, no breaks, no nothing. You're to work the whole 8 hours.
There are no labor laws which prohibit that unless you are under 16 years of age. There is no federal or state law, in Florida at least, that limits the amount of time you can be required to work consecutively without a break. I remember in the days when I first started working in New Jersey, there were such laws. There is no federal law and there is no Florida law in that regard. If you're under 16, there are certain requirements. 4 hours, after 4 hours working, you have to have a half-hour break. If you're under 18, there's a lot more freedom, but there are still certain limitations. But for an adult, if they want to make you work 23 hours in a row, you have two choices in Florida. Live with it or quit. And that's harsh, but that's at-will employment. You there, Jeff? Have I given you a heart attack? I think maybe Jeff was listening to the answer and left us.
Jeff, you still there? Somebody's still on the line.
Well, okay.
He's gone
all right.
Now. Well, we work our staff here 23 hours a day.
No
breaks.
Yeah, that's the reality, folks. People call us and say Florida's a right-to-work state.
Yeah, what is that exactly?
That is mixing up terminology. Right to work and at will used to be terms that described whether you could be fired for any reason except an illegal reason, or whether you had to be fired for cause. It is no longer that way because I think 48 states now are at-will employment states. So forget right to work. I think maybe California and New York may still be right to work states. Right to work now more generally refers to labor unions.
Oh, okay. Yeah, closed
right.
unions.
And when there are labor agreements, union agreements with the employer that provide termination with cause or termination and appeal rights, grievance rights, people will generally refer to that as a right to work. And that's basically correct. But overall, unless you have a agreement like that with a union, or unless you have a contract of employment which says you can only be terminated for cause, you are an at-will employee. And we've talked about this many times on this show. In Florida, at-will employment is the most harsh of anywhere in the country. In Florida, at-will employment simply means you could be terminated for no reason. You could be terminated for an unfair reason. You could be terminated for a good or a bad reason. You could be terminated for a factually correct or incorrect reason, like money was missing from the drawer, you're fired. And they find the money that night, and you want your job back. They don't want to give it to you? Tough luck. The only thing in Florida you really can't be terminated for, it's what's considered an unlawful reason, either under state or federal law. And those are very limited. Under federal law, basically, you're talking about Title VII of the Civil Rights Act, discrimination on the various forms of prohibited classification, sexual harassment, retaliation, things of that nature. Florida has some statutes also. The Whistleblower Act. If you've gone to your employer and said, I'm going to report your illegal dumping into the ocean, and you're fired, you have a cause of action. If you don't go to your employer and say, I'm going to report you, but you go to your employer and say, I know we're illegally dumping and I can't be a part of that, and you get fired, you have a cause of action. So the Whistleblower Act being punished for filing a workers' compensation claim, those are actionable under Florida law. So unless you're dealing with some of those very limited circumstances, you are a pure at-will employee.
You mean people actually get fired for filing a workman's comp case?
Oh, happens all the time.
Really?
And the workers' comp attorneys that get the case usually call somebody like me to handle the retaliation part of it. And I'm happy to do so.
Wow.
Other states have at-will employment, But their legislatures have enacted statutes which modify the harsh effects of it in Florida. Some states say, all right, you're an at-will employee, but you can't be fired for anything that would violate public policy. Okay, that gives you some good protections. Some are even more specific. You can't be fired for A to Z. All right, at least now you know the other things that you're protected for. But Florida is essentially a pure at-will employment state. We have no common law exceptions. Our only exceptions are statutory, and as I just discussed, they are very limited. So if you're going to call the office and say, I know this is a right to work state, we're not going to tell you you're wrong. We are going to explain at-will employment and try to figure out whether under at-will employment you do or don't have a cause of action.
And it's our right to tell you that you work. Is that what you're saying?
Well, I mean, you can tell us you work. Hopefully you work. Hopefully you haven't been fired.
Oh, man.
All right, so back to the parenting stuff. So changes in the amount of time spent is the last thing we discussed with the kid. Now, also, what happens at some point, you got a parenting plan, a court order that says, Johnny is supposed to be with mom during this period of time, and Johnny is with dad during that period of time. And Johnny says, I don't want to go to mom this weekend, or I don't want to go to dad this weekend. I'm trying to be fair, gender fair. When can Johnny determine for himself, or Jeanette, what rights they have? There is no fixed law in Florida, but generally, once the kids turn 15, really 16, they start to have much more of a say in whether they have to go to mom's or they have to go to dad's. All right, I'm supposed to be at mom's this weekend, but man, Mindy's having a party and I want to go to the party. Mindy doesn't want to go to mom's for that weekend because it's a party. And dad says you don't have to go. And mom says, I'm going to take you to court. Mom, you're probably going to lose. And you're not going to spend $10,000 over that one issue, let me tell you. So it has to happen a lot of times. So once the kid gets to 15, 16, if, let's say, you really were in court on a motion for modification, and the two exes are arguing over, they're not following the parenting plan, and they're not following time-sharing agreements, and the explanation by the one parent who's being accused is, well, my kid doesn't want to do it. Now, that's not going to cut with a kid that's 6, 7, 8, 9, 10. You better follow what the court has ordered. But when the kid gets to mid-high school, and you actually, hopefully you don't, but you're actually in court on a trial for a modification of a parenting plan over this, or for an order for contempt, the court's going to listen to the kid. The kid may be questioned in judges' chambers, make the child more comfortable, without the parents in there. Sometimes even without the attorneys in there. Judge has the right, the minor, to determine what does the child want and why. What the child wants is less important than the why. If the why is rational, well thought out, a judge is probably going to say, okay, I'm going to let you do what you want to do, or I'm going to let you do what you want to do to this extent. And there'll be a modification order so that the parent who's being accused of violating the court's order is off the hook because now we have a revised order.
What if you have a shared custody case?
Most of them are.
And one of them, people, moves to, say, California,
All right,
or Hawaii, or Arizona or something.
One of the next reasons we were going to discuss about reasons people call for a modification order. First of all, most parenting plans that the courts bless if it's thought out in advance, have a provision that says, let's say the primary custodial parent, even though you have shared custody, the person who has the kid more than 50% of the time, you cannot move out of the county, or you cannot move out of state, and definitely you cannot move out of country without first getting an order of the court. You have to show that there's a reason for you to do it, and that the non-custodial parent's rights to time sharing will somehow still be made available.
Yeah, but how do you do that if it's coast to coast?
Well, I know of situations where it's done like that. How do you do it? Okay, here's an example of how you do it. Dad, let's take the normal gender roles, okay? Don't shoot me, people. Mom has the kid most of the time. Mom wants to move to California, has a better opportunity for a better job, and files a motion for modification of the parenting order. Dad objects. This is going to make it so much more difficult for me to see my child. That is not fair. Now, the court will seriously take that into account. The court will look at, okay, Dad, how often do you really exercise your time-sharing rights? Are you abandoning them most of the time? Are you following them all the time? Are you even asking the other parent for extra time? How involved really are you? Are you going to all the baseball games, all the ballet recitals? How involved are you in the child's life? And the younger the child is, the more important this is. Because now you're pulling the child away from another parent that is intricately involved in the child's life. If it is really important for that primary custodial parent, let's say the mom, to move, because, here in Florida, you're earning $20,000 a year, and you just got a great job in California, it's going to earn you $45,000 a year. Be able to provide more for the child. Very often, and what I have seen, are orders like this. All right, we're not going to do the week on, week off anymore, or however it's set up, because it's not feasible. But we are going to get the dad, in this case, almost as much time as possible in terms of the percentage of time sharing that existed. And we're going to do it in ways like this. Every spring break and every winter break, you're going to get the kid. The mother who has left to move to California has to buy the plane tickets, pay for the plane tickets, and get the kid here back to Florida. So now the financial burden is being put on the person who created the situation. If winter and spring breaks aren't enough, well, instead of, let's say, having the child, half the time in the summer, which was the old plan, you're going to have the child the entire summer except for, let's say, 2 weeks. That's how the court tries to deal with those situations. You can't have the child going back constantly because it's not feasible, it's not in the child's best interest, and it's expensive.
Yeah, and you don't want a child flying on an airplane
Right.
alone either.
But you can have situations where 2 or 3 times a year, during the major times off, you get to have your child, and the other one has to pay for it. And that's one of the ways the courts will modify the parenting plan in situations where one parent wants to leave the state and go far away, or halfway far away, go to Texas. Okay? Any place where it's not going to be convenient to exercise normal time sharing. Now, the parent wants to move from St. Lucie County to Palm Beach County. Oh, my goodness, that's so far away. Let's say Jupiter. That's another planet. Okay, bad joke.
No, it's true. Have you seen some of the wackiness that goes on down there? Never mind.
Have you seen the wackiness that goes on at Walmart? All right, anyway, so the parent wants to move to Palm Beach. Now, look, that can cause a little bit of inconvenience, additional time travel. It's not the easiest thing, especially if you really have a great relationship. You go to all your kids', band concerts, baseball games, chess matches, whatever they are, debates. And, Palm Beach County now makes that a little bit more difficult to go to all of them. The court's going to consider that and try to do the best a court can do in a situation. Realize the court can't solve everything. Two cooperative parents can do that much better than the court can. But if it's up to the court now, all right, Mom, you can move to Palm Beach County, but during Dad's time sharing, you're getting the kids back to St. Lucie County. And instead of, let's say Dad bringing them home, you're coming to get them too, to bring them back to Palm Beach County. We're not going to put that onus on Dad. So those are examples of things that could be done.
So how long does this modification, say, if you get a job in California, and they say you got to be there in, 2 weeks, how long does this court thing go?
Oh, if you got to be in there 2 weeks, tough luck. You better not leave without the blessing of the court if you have a provision in the order of dissolution or in the parenting plan that is incorporated into the order of dissolution that says you may not leave without leave of court. Then, if I am the dad, I'm moving for an order to show cause while you shouldn't be held in contempt. And then whatever conditions may be imposed may be even better for me, because you violated the court's order.
Does that happen?
Yeah, it happens. If you're going to look for a job, now granted, sometimes it just is thrust upon you. That's difficult. Try to negotiate. Get a mediator involved. Try to come to some agreement without having to wait for the time to get to court, because that's not an emergency to the court. That does not involve the child's immediate health or safety. That's your emergency. Not enough judges to hear that right away. You're going to wait your turn. Okay? So if for the following reason, it's much better if I look for a position in California, and you're going to start that job search. Start trying to work it out with your ex. Start trying to get a mediator involved. Or if you have to, file a motion with the court now, and maybe 3 months from now when you get the offer, you might be able to postpone the job start for another 2 months while you try to get that hearing. But if you leave when the order says don't, you may be dragged back here, and in fact, you may be told, no, we're not going to permit you to leave, and now you have to quit that job and come back here, find another job. Remember, the talisman of family court is the best interest of the child, not the best interest of mom or the best interest of dad. It's the best interest of the child. So don't violate the court's orders.
Interesting. Okay.
So what other types of battles often lead to these modification motions? Well, parents are disagreeing over the transportation of the child. It could be petty. It could be serious. It could be one time. It could be 1,000 times. Parents disagree over reimbursement of medical expenses. That can add up. Parents disagree over school-related issues. I don't want Johnny being in baseball. That's going to take away from his schoolwork. And the other parent says, no, baseball is very good to learn teamwork and leadership. And now you have two people fighting over whether Johnny can be on the baseball team. Now, are you going to go to court over that alone? No, it's silly. But if it's that, and if it's transportation, and if it's this, then if you can't end up finding some way to get into an agreement, we'll talk about that in a little bit, you may be filing a motion for modification.
But do things actually get that petty?
Yep.
Okay.
Do divorces get petty?
Yeah.
Well, post-divorce issues with the kids can get petty. Trust me, I know. And not just from clients calling. You can read between the lines, folks. All right, so now what about, here, we just talked about this. Parents disagree not over moving out of state or moving out of the country, but travel, vacations out of state or out of the country. Now, generally, that is already provided for in the parenting plan. There is a section in Florida's standard parenting plan that has a section you can put in the agreements you're making on those issues, or if you don't and you have a trial, what issues the court determines. For example, you may be able to take the child out of state freely. Just give a certain amount of notice to the other parent so they know where you're going, and maybe you have to give an itinerary. They know how to contact the child, things like that. It seems very reasonable to me. You want to go out of the country. Okay. You want to go to a cruise that's going to go into Mexican waters. That sounds normal. You want to go to Canada to visit relatives. I have relatives in Canada. That sounds normal. What if mom has a boyfriend from Colombia and they want to take you to Colombia for a vacation? And you're worried, is that kid going to come home? And if they keep that kid in Colombia, how am I going to get my kid back? That is probably addressed in the parenting plan, hopefully, and says, okay, you have to give a certain amount of notice if you're going out of the country so that the other parent can file an emergency motion and get heard as to whether the other parent can take the kid out of the country, and if so, what protections are being afforded. Is it a $100,000 bond until the kid's returned? What is it? What are other protections to make sure that child is coming back? Okay? If it's a real issue.
What if they don't come back on time?
All right. Then you have a treaty that we have entered into with most civilized countries, just like any treaty, not every country. And an order from the United States properly transmitted to another nation will be enforced. Now, that takes time, but typically, Canada, Mexico, other states, will then order the child to be returned home.
But who enforces that on that side?
The other country. If it's part of a treaty, then hopefully it's going to be abided by. If not, now you have a problem, because now you got to go to the State Department and ask the State Department to get involved to enforce the obligations of the foreign country to abide by the treaty. And while the State Department will make some efforts, they're not your cop, and they have a lot of other things to do. And you hear, State Department gets involved in things that are high profile. If you're not high profile, you may not get their help as much. So maybe you make it high profile. You go on CNN, you go on MSNBC, and now the State Department feels they have to do something. This we're going
squeaky wheel routine.
Yeah. We're going to extremes here, but if the child is going to go out of the country and there are not already pre-thought out provisions that are in the parenting plan that have been incorporated into the order of dissolution, then you, as the parent who is not taking the child, and if for whatever reason you have a legitimate concern, like the mom's going to the boyfriend's home country, and things haven't been so great between the two of you, and you've already had issues here at home with changeovers of custody, then you're going to get into court immediately and say she's about to abscond with the kid out of the country, presumably on a vacation, but I have reason to believe that may not be true. I need protection. That is the kind of matter the court will probably hear very quickly. But you may have to file a motion. And it's a real concern when you hear kids going to go out of the country. Even in decent ex-parent relationships, ex-spouse relationships, even in decent ones, when you hear the kids being taken out of the country, you have some concerns. Maybe they're minor, Maybe they're low level. But if you don't have any concern at all, you're not thinking clearly. I mean, look, I was going to take my son to Montreal last summer until certain circumstances precluded it. And I got a notarized affidavit from my ex that indicated she was in agreement with me being permitted to take him out of the country. Now, of course, you don't need a passport to go to Canada. So you do need an affidavit like that because they may stop you at the border and say, without the permission of the other parent, we're not letting you come. Cruise lines are notorious for that. If you're traveling with one parent, they say, do you have the consent of the other parent? And if you can't produce documentation, you're not getting on the ship.
I've never heard of that.
I have been in line where the person in front of me is begging and pleading, and I hear customer representatives say, they will do everything possible to get you on that ship. Let me call your ex. Let me see if they can fax the affidavit. They'll do whatever they can in the time provided. But if not, you're not getting on the ship because there's too much of a concern of parental kidnapping. So you get an affidavit like that. Now, if you get a passport for the minor, as part of getting that passport, the other parent has to provide an affidavit that allows you to obtain the passport for your minor child. That mere cooperation in getting the passport is permission to take the child out of the country. So if you want more protection than just the passport, it had better be in the parenting plan, the order of dissolution, or you better go to court and change it because you've just agreed that that kid can go out of the country whenever they want because you've agreed in allowing the other parent to get the passport.
That's interesting. Wow. It's complicated.
Come on, folks. Give us a call, 340-1590.
Oh, man.
All right. So what about if parents are disagreeing over holiday or school break arrangements or summer arrangements? Presumably addressed in the parenting plan, but, circumstances sometimes warrant changes. Grandparents are visiting from far, far away on a week in the summer that's supposed to be the other parent's. The other parent says, no, I'm not agreeing to let you have the child. Well, on that, don't tell anybody. But if you keep the child, the judge is probably not going to do anything if it's ever taken to court because the other parent's acting absurd, especially if you offer, to trade. And that's a really great thing a program called Our Family Wizard is designed for, where you can propose a trade, and if the other parent ignores it or rejects it, it's really clear the efforts you've made to work this out.
Sounds like a baseball team, a trade.
That's what they call it, a trade request.
Oh, no.
I'll agree to this in exchange for a child to be named later. All right, and here's another biggie. We mentioned disagreements over school-related issues. Oh my goodness, what if there's serious disagreement over medical-related issues, over treatment issues, over medication issues? If you can't resolve that on your own, and you can't resolve that through somebody you trust, like clergy, acting as a mediator, if you can't resolve that through a mediation, then it's only resolvable in court. That's a shame, but it is. Medical treatment. You want to take your child to a particular psychologist, and the other parent says, oh, no, I'm not agreeing to that psychologist. Well, unless there's a real good reason, if it has to go to court, the court's going to side with the parent who's predominantly making the medical decisions. No reason not to go to that psychologist, unless maybe that psychologist is an ex-girlfriend, and your ex-wife is afraid that it's going to side with you more often. I mean, those are real things that happen, folks. They happen. And they're legitimate concerns. All right, so now, consequences of filing a motion for modification. It's expensive. As I noted, it typically takes a year to get your hearing. Your attorneys are going to engage in discovery if necessary. You're going to have to exchange financial documents again. You're probably going to be required to go to mediation. This can run into thousands and thousands of dollars, or $10,000 or more. So before you decide you're going to run to court seeking a modification, you've better decided that it's worth it and you're willing to spend that money. If so, then you probably have a real serious issue, and God bless you in protecting the best interest of your child. But if it could be resolved in some other way, resolve it. Because you don't want to spend that money unless you have to. Now, what else happens? Time to get to the hearing, aggravation of discovery and trial. You've just got to be prepared for the consequences, the necessary normal consequences of litigation. And if you can avoid it, avoid it. So now, how can we avoid it? What are the alternatives? Well, one is the parents being able to talk among themselves and make agreements that temporarily modify the parenting agreement, and nobody's going to run to court to tell the judge, oh, they're not following it. If you agree amongst yourselves, and it's not contrary to the best interest of the child, court's never going to know about it. Nobody's ever going to bring it to the court's attention. And if it works for the two of you, it's probably okay. The order says you're to have the child the first and third weeks of the month, and the others to have the second and the fourth week. Oh my gosh, the order is silent about the months that have 5 weeks. What do we do? The two of you had better be able to figure it out. Okay? What if you want to switch weeks? Switch weeks.
Easy for you to say.
Right. Come on, figure it out. If you can't, go to somebody you trust that's impartial, whether it's clergy or somebody else, and try to resolve it.
Yeah, I wouldn't think you'd want that at court to.
Or if you both already have attorneys because of the bitter divorce battle.
Oh, God.
Let your attorneys try to work it out.
Cha-ching.
Well, that may be much less expensive than a modification. Okay? If the issues are multiple, if the issues are significant, if behind the issues is the inability of one parent to simply converse with the other, or both parents, often one parent, then I know this is going to sound funny, but the rational one of you needs to propose a peace treaty. Everybody's laughing here. And you need to send that peace treaty not to the ex that's going to go nutso over it. You send that peace treaty either to your lawyer to try now to work with the other lawyer on, or you send that peace treaty to a clergy member you trust and who's willing to get involved to try to barter an arrangement between the two of you that is in the best interest of the child, so that you don't have to spend all that money on going for a modification.
How about sending that to the clerk of the judge? No?
Not going to work.
No go, huh?
No, that's not going to work. They can't deal with it. There has to be a motion, and then you got to go through the procedures. Sending it to the clerk is like sending it to Santa Claus. And leaving milk and cookies out and hoping that they're eaten, but not by the kids, for the parents. So, a peace plan often, like any two warring parties, will have elements where each parent is getting something they want and conceding on something they want. But the most significant aspect of a peace plan needs to be items that are solely for the benefit of the child. Because those are the items on which, if the other parent cannot and will not agree, may compel you to go to court. And may rationally and reasonably and necessarily compel you to go to court. If I want X and my ex doesn't want to do it, even in exchange for Y, I don't think I'm running to court over that. But if the child needs certain things, wants certain things that are rational and reasonable, and it's more than one issue or two issues or even three issues, and the two of you can't agree for the child's best interests, you better have somebody else that you rely upon that can help negotiate or mediate or even have a written peace plan prepared that they can work from, because the alternative then is going to court or just being in a state of war. I see I have a text message from my son. I am hoping that it is not about this topic. I don't think my son is listening to the radio show, so let me just, this is standard for my son. Please get food on your way home. That was not something for me to look. That was not something for me to interrupt the show and look at a text message for. But that is typical of my child.
Bring food.
Yes. It's not like we don't have food in the house, We just had, I like having Shipt Deliver because I hate the grocery store. We just had Shipt Deliver like $250 worth of food. But please bring food home, Dad. No. When I get off the show, it'll be kid. We have plenty of food in the house. Find something to eat in the house. Kids, that's amazing. All right, so what happens if you've had these problems and you haven't been able to completely agree? You've had progress, even if it's with help, but you haven't been able to completely agree. I suggest you ask yourself some questions. Were you able to get most of what you want? Were you at least able to get the key issues important to you? Were you at least able to get the things that are important and in the best interests of the child? Can there be a rough peace that exists even informally? If the answer to all those questions is no, then you probably need to go to a lawyer. But if you can do any of those things or get any of those things, I suggest you live with it. I have some issues with my ex. And we have a mediator of sorts. And there are times where the issues get strained. If you're watching me on Facebook Live, you see this mischievous grin on my face because I'm being diplomatic. And hopefully you have somebody who can assist you in trying to deal with the points of a peace plan in a fair and reasonable manner and trying to get both parents the key issues of what they want that benefit the child and most of the issues that are solely designed to benefit the child.
What happens if one of the parents has a health issue that precludes them from bringing a child back and forth?
Well, that is a legitimate consideration. I mean, if there's a health issue, then hopefully it's been dealt with either in the parenting plan, or if it's a health issue that arose after the parenting plan, one would hope that the other parent would be cooperative. I think one even would have a reasonable right to expect the other parent to be cooperative. Not necessarily to be the chauffeur, but to be cooperative. And now it's a question of degree. Can you two work out enough cooperation so that you, who has the health issue, gets what you need for the most part in terms of transportation? And if the other parent wants something in exchange, that's life. We're human beings. Is it something that you can live with? Is it something that's rational? Is it something that makes sense? Or if it doesn't, is it something you can tolerate? If so, come to your own agreement. Work it out. And if it's an issue that is really not for the other parent's benefit, but for the child, think very carefully before you say no. Because if it's really just for the benefit of the child, and that's the condition that the other parent is putting on it, you might really want to say yes. Because a court ultimately is going to look at that and say, that parent wasn't even asking for anything for themselves. They were asking for something just for the benefit of the child. And you said no? You're not going to come across looking very well. So, before you really go through with a modification, I mean, it's okay if you call a lawyer. It's okay if you call me. It's okay if you want a lawyer to help you draft it and negotiate it. That's all wonderful, and it's a lot less expensive. But before you truly seek a modification, consider the best interest of the child first. Consider any alternatives short of going to court for a modification. And if your own emotions are running high, as I know mine often do, try as much as possible to keep the emotion out of it and be practical. And, we only have a couple minutes left, but, if you've got a file, just realize the length of time it's going to take, the cost it's likely to take, the emotional aggravation it's going to cause, and what impact is it going to have on the child. So, the real bottom line is, if you can find an alternative, find the alternative. And if you can't, and you're trying to do this peace plan type idea, make it as practical as possible. Make it as mostly in the best interest of the child as possible. Anyway, I sort of hear the music, which means like the Academy Awards, they're going to cut me off. Give Cheryl a call at the office, 781-8003. I hope you all have a wonderful weekend. It's Father's Day. Treat the fathers nice. Moms, don't interfere with Father's Day, please. And I'll see you next Friday. Talk to you next Friday. Hope you have a great weekend and a great week. Thank you.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie, WPSL.com, webcaster to the world, on Alexa and Google Home.